Hi everyone, I am Samidha Hegde. I am interning with LEXIS and Company and I am a third year law student studying in Ramaya College of Law, Bangalore. Today I am going to be explaining you about exchange under Transfer of Property Act 1882. Now exchange is very self-explanatory from the word itself. Exchange means simply taking of one thing in return for something else. Now this is mentioned under section 118 of the Transfer of Property Act. Now here it is defined as when two people exchange, voluntarily exchange ownership of one property for another, then it is exchange. And remember that both the thing cannot be money. You cannot exchange money in return for money. And the essentials of exchange are that there must be two parties, and transfer. Here there is no consideration involved. Now, other than exchange. Now, voluntary exchange of property itself is a consideration. Apart from that, there is no separate consideration. So the difference between exchange and sale is that in sale the consideration is, if I am transferring some property, the consideration will be the market value of the property for me. So that will be the consideration. But here two people voluntarily agree to exchange one thing for another. Now remember that here the transfer is of complete ownership, that is absolute interest, unlike in mortgage where only there was a transfer of interest and it was not absolute interest. And transfer of property under exchange can be of both movable as well as immovable property. Now, like I told you, it is even immovable properties included, and that is why it includes barter exchange or barter system. Now, you might have heard of barter system that was practiced earlier when there was no concept of money. In those days, people exchange one thing for another, like for example, exchanging food grains instead of clothes or shoes. There was no money, and that is how people traded in those days. Now that also comes under exchange. Now mode of transfer is same as that is under sale, under Transfer of Property Act. There is no difference. Suppose it is movable property, then delivery of possession is necessary, is sufficient. There is no registration necessary. However, if it is immovable property, then whenever you make a transfer, then registration is necessary. Only exception is that if the immovable property is valued under 100 rupees, in that case there is no registration required. I don't know what immovable property you can get for less than 100 rupees, but anyway, if it is an immovable property that is worth less than 100 rupees, then registration is not required. But for anything above 100 rupees, registration is compulsory. Now, what are the remedies available to a person if the title is defective? Let's say while exchanging, I gave you some property which does not belong to me at all. I'm not the original owner of the property, and later you find out that I was not the original owner. So what are the remedies available to you? So under section 119 of the Transfer of Property Act, there are two remedies. That is, you can either claim for compensation or you can take back the thing that you gave me. Whatever you had given me during the time of exchange, you can claim it back. So yeah, I guess that's all. Hope you understood what is exchange under Transfer of Property Act. I have made other videos also on transfer of various other topics under Transfer of Property Act. Do check them out. And please share, like and subscribe to the channel and press the notification button for more updates. Thank you.